The First Amendment is a complicated enough topic that in law school, often we have an entirely separate class on the First Amendment, divorced from the rest of constitutional law. So this video and the video that follows will deal with all the topics that are typically within a Con Law 2 class. And that means we're going to focus on the First Amendment. In this video, we will touch on the issues related to religion, and in the following video, we will go into freedom of speech, by far the most complicated and most important of the individual rights that are testable on bar exams across the country. Now, for our purposes in this video, the religious freedoms are quite simple and straightforward, and they are tested very simply and ritualistically. The more practice you do, the more you will see how true this is. Religion is not a complicated topic on the bar exam. And here, we're basically dealing with the right to freely exercise religion and the right of all of us not to have an established religion. So, let's begin with the free exercise of religion. The basics of free exercise are everybody in the United States of America has absolute freedom to believe anything they choose to believe. Government will not interfere at all with each individual's right to freely believe anything they want to believe about religion, cosmology, etc. However, the state does have the power to regulate activity based on belief up to a point. And that's where you will get into the animal sacrifice cases, and also cases where individual practitioners of religion want to use certain drugs. There are a series of cases involving peyote, and there are recent cases involving marijuana. And there's been congressional action as well about the free exercise of religion where it comes to regulating activity based on belief. This is fairly interesting material, but it's not terribly complicated. Do some practice questions. You will see quickly what the contours of this law are. Now, the most interesting area of the free exercise of religion is almost never tested, and we'll touch on it just for a moment. There are issues where the courts are called to resolve disputes involving religious institutions. The foundations of these lawsuits will be usually in a breach of contract or in tort theories. And obviously the courts are available to resolve disputes that involve religious institutions. But there is a bright line that our courts will not cross, and they won't even cross it when it's time to resolve a dispute within a church or a religious organization. Where one of the issues between competing litigants in a religious case wants to discuss church doctrine, the courts will never reach a decision about which doctrine is correct. And any of us with contact with any organized religion knows that within each of the faiths, there are certain doctrinal disputes. There are splits within almost every religious group dealing with doctrine and dealing with ritual. The courts will stay away from trying to interpret religious doctrine as it relates to broader disputes. So that's really a free exercise issue ultimately. The courts are not going to monkey around trying to decide what is right in a religious dispute. In a contracts dispute, in a torts dispute, in a property dispute, or in a dispute involving business organizations, the courts will have no problem resolving the dispute, even if it involves different religious groups. So the free exercise clause is by far the more simple and by far the lesser tested set of issues relating to religion. But the establishment clause is commonly tested. You're almost certain to see questions about it on any administration of the multi-state bar exam. And when essay questions touch on religion, almost always they are dealing with the establishment clause. And here there is a three-part test derived from the famous Lemon case, and we see them in our little laundry list. There has to be a secular legislative purpose. The primary effect of this legislation has to be neither to advance nor to inhibit religion, and perhaps most importantly, government cannot entangle itself excessively with religion. And there's been quite a bit of litigation on these issues in the last 15 or 20 or 25 years, and I think it is likely that you will see this issue in play on any given bar exam. Now, let's take a somewhat more careful look at how some of these Establishment Clause issues are tested. The most important thing for you to do is memorize the three-part test. This is something you really have to know, and you have to be able to call up that three-part test for essay purposes. You've got to be able to narrowly and specifically look at the facts in a given essay question and connect them to elements of the Lemon test, then reach a conclusion as to whether or not the case is an example of a violation of the Establishment Clause. Now, as we look at state regulations involving religion, we can see examples in which the state is seeking to aid all religious activity rather than the religious activity of merely one group. Now, one would think that just on its face, that would not constitute an Establishment Clause violation. But in fact, depending on the details of each individual situation, it is possible that a state activity, which at least on its face appears to encourage all religions equally, can still in practice constitute a violation of the Establishment Clause. This is an issue that you're likely to see in practice, and you'll see, particularly in multi-state practice, that it's pretty easy to spot the issue, and at least compared to contracts or real property MBE questions, the MBE questions on con law religious issues are pretty straightforward. Where we have a state that is requiring public schools to teach religious doctrine, here again, we're on pretty shaky ground with regard to an Establishment Clause violation. It is true that public schools that offer religious classes as electives, particularly overview religious classes that touch on a number of different faiths, these do not violate the Establishment Clause. However, the more narrow, the more specific, and the more required a religious study is, the more likely it is to violate the Establishment Clause in a public school. We know that there is power on the state's behalf and on the federal government's behalf to regulate religious activity. But to do so, they must be able to show a compelling state interest. Remember, religion is another fundamental right. With regard to conscientious objectors, this is a very commonly tested issue because it's one of the more important religious issues. We have a conscientious objector who refuses military service. Since we no longer have a draft, the most common way that this situation arises is where we have an active duty member of the military who becomes more religious than he or she was before entering service. With regard to conscientious objectors, we will never examine whether or not those ideas are valid. We'll pretty much stipulate that it is possible to be a conscientious objector. However, in an individual case, we are free, we the government, are free to examine whether or not an individual's belief is a sincere belief. If we've got someone who is basically mouthing religious phrases in order to avoid military service, we can still order that person into combat. But where we have someone who truly has engaged in a religious conversion or in a religious rebirth, under those circumstances, conscientious objectors are likely to be respected by the government. Now, with regard to religious activity as a whole, I think it is fairly easy to make the distinction between whether a given question is dealing with free exercise or whether it is dealing with the Establishment Clause. And on some MBE questions, you'll see that free exercise may be one of the answer picks and the Establishment Clause may be another answer pick. Well, go in and do a lot of practice. You'll see this material is tested in a quite straightforward manner. Now, that wraps up a very quick discussion of religion. This is not a heavily tested area, and to the extent that it is commonly tested, the material is very straightforward. So, in our next video, the last video dealing with individual rights, we'll get into the most complicated set of issues of all, those dealing with First Amendment freedom of speech issues, and we'll also touch very briefly on freedom of association.